Welcome to the regular meeting of the San Francisco Ethics Commission. We will begin by taking the roll. Commissioner Studley.
Here.
Commissioner Liu.
Here.
Commissioners Hayon and Rennie have been excused. The first item on the agenda is public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
I want to talk about the decision to hear and take possible action on the Netshaw complaints. Mr. Chatfield, who is not here, wrote Mr. Netshaw in May. The Ethics Commission regularly handles referrals from the task force. However, it will not adjudicate these matters as the executive director is a named respondent in both complaints. He repeated that in his confidential memo to Mr. Shen and to Mark Katz of the District Attorney's Office. Because the allegation involved John St. Croix, executive director of the Commission, the agency cannot handle the matter. Period. Commission is engaged in a discussion with various outside agencies and so forth and so on. That was in August of last year. I did a record search of your files. I just came back from sitting in the Commission's offices. There are absolutely no records of any kind relating to discussions with any other agencies. The references to the San Jose City Attorney's Office are dated 9 months after those two memos. But I think what's really important is that there's I think a reference in an email that it was Mr. St. Croix who spoke directly to the San Jose City Attorney about taking these cases. So what we don't know is how this magically happened 9 months later. There are also no emails or other written communications of any kind internally within the staff or with any of the commissioners, with one exception, which I'll give you in a moment. So there's no way to track how this all came about. It's obvious that none of you were directly involved in the decision, which, considering that it involved your appointee, it had to be completely transparent, and it had to be one that everybody would accept. I did find an email from the chairman, which surprised me. It said, it went to Mr. St. Croix. Shaw's complaints. Is there any reason why we can't release San Jose's excellent analysis about why Shaw's complaints fall? Does that indicate that this is the right place for you to hear these cases? I don't know much about ethics, but I know that this isn't right. I have a lot of other information on this, but I think since my time is up, you should carefully think about what you're doing. Carefully.
Commissioners, Ray Hartz, Director, San Francisco Open Government. The Sunshine Ordinance, Section 6716 minutes reads, quote, any person speaking during public comment period may supply a brief written summary of their comments, which shall, if no more than 150 words, be included in the minutes. That is the plain English reading of the ordinance. And the Sunshine Task Force has ruled 4 times, including once against this body, that in the minutes means in the minutes. And yet Mr. St. Croix insists that he is keeping them out because the city attorney says you can. In the task force case number 11088, this Ethics Commission was found in violation of the ordinance To date, this Ethics Commission has both refused to comply and refused to even hear the referral by SOTF to ethics. In fact, what you produced was a 134-page response trying to justify it, which is a load of crap. Why are you so afraid of having comments from the public be presented accurately in the official records of your meetings? Why do you insist on placing the 150-word summaries in an alternative location, substituting in their proper place in the minutes your censored version of those comments? And why have the members of the Ethics Commission abdicated their responsibility to Executive Director John St. Croix in matters which go to the very heart of their open and honest operation? You know, it is a real shame that a citizen of this city has to actually fight with boards and commissions who take an oath to support and defend the Constitution of the United States and that of the state of California, to in some cases even have a chance to speak. And this is protected political free speech. And to represent it in some other way than the person who is speaking in the original official records is nothing but censorship. And you know it's censorship. And you want to censor it, which is why it has gone on this long. Included in one of the determinations from the task force was a directive to the city attorney to stop telling city bodies that not following the law as written is wrong, and to quit advising them to do it. And this has also been referred to the district attorney's office as well as this Ethics Commission.
Good evening, Commissioners. My name is Dr. Derek Kerr. I have a comment that relates to the Executive Director's report and your annual report to the Board. As you know, protection of whistleblowers is one of your mandates. It's in Article 4 of the Campaign and Governmental Conduct Code. But your work in this area is invisible. There is nothing about whistleblower retaliation in your minutes for the last 7 years, or your director's reports, or your annual reports. Recently, the Controller's Whistleblower Program has been reporting retaliation complaints. 17 this year, none substantiated. In fact, since 1995, none have been substantiated by this body. Now, each year you are required to provide a report to the Board of Supervisors. One requirement is that you note the number of complaints that you've received. Another requirement is to report, quote, the type of conduct complained about, unquote. So please consider adding whistleblower retaliation to the categories of complaints that are listed in the Director's report and that should be listed in the annual report. It would raise awareness about this issue and would give visibility to your work and to the work of whistleblowers. Thank you very much.
Good evening, Commissioners. I'm Patrick Manette-Shaw. First, I note that on the handout table there's no response from the Mayor to your inquiry last month about the fate of Joel Gomez. It's really odd that he's taking so long to reply to you. Second, I asked Mr. Chatfield this morning to distribute 2 letters that I only recently received late last week. One of them, a copy of it is there. You'll notice in the margin there's an asterisk next to the paragraph in which Garrett Chatfield wrote to Mark Katz and Andrew Shen, quote, because the allegation in my complaints involves John St. Croix, Executive Director of the Ethics Commission, this agency cannot handle the matter. The Ethics Commission has engaged in discussions with various outside agencies to determine if the matter, which would normally be handled by the Ethics Commission, can be referred to another agency. I indicated to you last month I don't believe you should be hearing this case at all. You should transfer it in its entirety. That would be in toto to another jurisdiction, not just merely to obtain an opinion from a deputy city attorney who clearly didn't understand the rules. Next, I'd like to draw your attention to the fact that Mabel Eng, the Deputy Director of the Ethics Commission, had violated the Sunshine Ordinance back in 2007 or so, and that complaint was referred to the Oakland Ethics Commission, I believe, in toto. And the Ethics Commission, possibly before your tenures, accepted Oakland's determination in that case. I am asking you again to transfer my case in its entirety to another jurisdiction. There is a clear conflict of interest with this body adjudicating a flawed analysis from the San Jose city attorney, and you should refer the whole matter to another jurisdiction. And finally, I would like to congratulate the 4 courageous members of the Board of Supervisors who rejected the referral from this body concerning Ross Mercarini. They, unlike you, came to the correct ethical conclusion. There was no nexus, and therefore the sheriff can't be removed under official misconduct.
Hi, I'm Hope Johnson. I just wanted to, I'm not sure how long I'll be able to stay, so on item 3, on the complaints that have been brought back with the recommendation by the San Jose city attorney, I wanted to bring to your attention one thing in our argument. I was on the task force at the time these were heard. I also want to echo that I think that considering the great rifts that have come in front of the city and our leaders saying that they would like to have some sort of closure to that any even semblance of some sort of conflict of interest needs to be addressed in a way that makes the majority of people feel comfortable. And I think sending this somewhere else, even if it took a little bit longer, might help go down that path. In the back of this memo, in the conclusion part, it says that the task force did not apply the law correctly. I just wanted to point out to you for your consideration that in one of these complaints, the information that was sought was really about which department handled the complaint as opposed to the actual information that was traded. And at the time we had these hearings, Governor Schwarzenegger posted that kind of information online. About a week after we held our first hearing, Governor Brown took them down. So it's really not a matter of applying the law. In my opinion, it's a matter of the policy and the way that you want the law to be applied. It's not black and white. And it's something that the Sunshine Ordinance itself says whenever there's a conflict or there's 2 paths to go down, that the voters prefer to go down the path that leads to the most open government. Thank you.
Doctora Maria Rivero, I worked for Laguna Honda for 22 years before I was driven out of there when I became a whistleblower against the administration at Laguna Honda. I want to underscore what Dr. Kerr said about the fact that you all have the responsibility to deal with whistleblower retaliation. And whistleblowers and dissidents are very important in society. And clearly, your finding of no whistleblower retaliation when the Government Accountability Project finds that the vast majority of whistleblowers are retaliated against begs the question about whether you guys are actually doing what you're supposed to be doing. Thank you.
The next item on the agenda is discussion and possible action on ethics complaint numbers 08110816 and 09110816, alleging that Executive Director John St. Croix and Tonia Lediju of the Controller's Office willfully violated the Sunshine Ordinance. I understand that we have or can get Lisa Herrick from the San Jose City Attorney's Office on the line. And I think we should try to do that. With respect to the this issue, I would like to give Mr. Shaw an opportunity to speak. I know that he submitted a response to Ms. Herrick's analysis. I have reviewed it. But I do want to give Mr. Shaw an opportunity to explain it and provide whatever response to Ms. Herrick he would like to provide. I don't really care which order we do this in, whether it's Mr. Shaw first, followed by Ms. Herrick, or whether it's Ms. Herrick first. Fellow commissioners, do you have a preference?
So you're talking about as to the merits of the complaint itself?
I am.
If we were to want to raise the question of what body adjudicates it, when would you consider that procedurally appropriate?
I think if a commissioner wants to raise that, we should raise that now before we get into the merits.
I think we ought to put it before ourselves and not just move into the merits stage. I think there are certainly perception issues about our ability to handle this. And I would like to hear your thinking and the other commissioners' thinking on it.
Commissioner Liu or Commissioner Sedley, if you had other things you wanted to add, I think we should.
I'm sort of working my way forward here, so
Okay. Commissioner Liu, do you want to? Do you have an opinion?
Thank you. I mean, I think that Mr. Minette Shaw and Ms. Johnson raised some good points about perception issues on whether we should be considering this at all or whether the entirety of these two complaints should go to be determined by a different body altogether. So I guess I would put it maybe a question to the city attorney's office about whether the parameters of conflict of interest or perceived conflict of interest and how it came to be that we received a recommendation from a different body, but then it would come back to the members for a determination, the ultimate determination, or how has that worked in the past? So if you could educate us on that, that would be great.
And to the extent that there was reference in public comment to a previous matter involving staff, if you know the specifics of that one.
Sure.
That'd be helpful.
I can't actually speak to what happened in this case because I was not involved in the decision to send it to an outside body. But I can tell you that this practice is consistent with the past practice of the Ethics Commission, when either a member of the Ethics Commission staff or even a member of the Ethics Commission is charged for the violation of one of the laws under your jurisdiction, that you find an outside entity to handle the investigation rather than in the shoes of the executive director. But then the complaint comes back to the commission ultimately to decide. I believe that the reason for that is that these laws, in the Campaign and Governmental Conduct Code, the city charter authorizes the Ethics Commission to make certain types of determinations, not a body appointed by by non-San Francisco officials serving another city. I don't know if that answers all the questions you were asking.
Well, and has there been occasion where all of it, the entire case was determined, which is handled by a different agency because the respondent was the San Francisco Ethics Commission?
Not that I'm aware of. So what I would say is the Ethics Commission does not have, the commission as a body, or even any of the five of you, do not have a legal conflict that would prohibit you from adjudicating this type of case.
Okay, thank you.
Do you or other staff members, does that include the situation involving the deputy director that was referred to earlier? Was that adjudicated by this ethics commission after legal analysis by Oakland, or was there another methodology? Thank you. I'm sorry to put you on the spot, but you probably do know better than anyone how it was handled.
Yeah, in that case, the Oakland City Ethics Commission conducted the investigation, provided a report to the members of the Ethics Commission. The members of the Ethics Commission took it up in closed session and made a determination.
The members of the San Francisco Ethics Commission ultimately made the decision.
That is correct. The ethics, San Francisco Ethics, yes.
Okay, thank you.
And I should add that there have been other complaints that are confidential because they fall within the confidentiality rubric of the charter that have been handled in the same way. Complaints against members of the Ethics Commission staff, where the Oakland Ethics Commission or perhaps another outside body has done the investigation, come back to the San Francisco Ethics Commissioners for a final adjudication.
Is there any policy reason that you're aware of that would prevent us from just having another body adjudicate the entire issue rather than having it investigated by another body but coming back to the members for the final adjudication?
You're asking whether there's a legal prohibition on whether you're legally permitted to send the entire matter to an outside body to adjudicate? Yeah,
I guess one question would be legally permitted, and then is there a policy consideration that I'm not seeing, I guess, for not doing it that way?
I'm not sure whether that you're legally permitted to send the adjudication to an outside body.
I see. The entire adjudication.
Right. If a single member, for instance, here the executive director has been charged with a violation, he cannot make decisions or advise on decisions involving his own character or conduct. But that doesn't mean that the Ethics Commission as a whole has a conflict. And because our local laws charge the Ethics Commission with making the final determinations in these matters, I'm not sure that the Ethics Commission could then send that final decision to another body to make.
Okay. So you think we may not be legally permitted to send the entire case to another jurisdiction altogether?
That's right.
I see. Okay.
Mr. Grossman, please, you sit down. There's time for public comment. There's time to hear from the parties. We will have that time. Mr. Hartz, I'm going to ask people to leave if we're not going to be able to sort of respect the rules and our procedures here. You will certainly have your opportunity to speak, and like I said, Mr. Shaw especially will have his chance. Any other questions for Mr. Givner?
I'm trying to think whether this is something that would be amenable to research, because it is our responsibility. And I just don't know whether the law is going to give us a crisper answer than that.
I mean, certainly I can see the legal problem with having a separate agency make a determination that we somehow pass through as binding. Now, could another city, county agency make a recommendation that we would then have to re-adjudicate? That sounds like something that would likely be possible. Mm-hmm. And right. Would the imprimatur of a completely an agency that's totally separated from ours provide assurances to the public that it was adjudicated correctly? Perhaps, although again, I still think, fortunately or unfortunately, we would be required to make our own independent determination. I don't think we could rubber stamp it whether it was one way or the other, and so I don't know ultimately how helpful it is. That said, I certainly have no objection if we could find such an entity to look at it. I mean, I don't necessarily have an objection to that. I just don't know whether it saves anybody any time. And certainly, I mean, sort of flipping it around, would we, the San Francisco Ethics Commission, be
would we do that?
Would we do that for another agency, knowing that really it was just a recommendation that the other would do whatever they wanted with? I don't know, maybe.
I'm tempted to refer to the recent proceedings in which there was a step-by-step process, and one entity, we built the record, and another entity, knowing what had been said in a transparent way, had to then tackle, and the individual members could agree or not agree, but people knew what that more separate entity had said. It's complicated, and I don't know whether anybody would take it, so we might have some time spent looking to see whether, and the law sort of doesn't like advisory opinions from bodies with adjudicative responsibility, but I'm also trying to think about what would make this stand and be credible, and our own analysis. I mean, we have not heard the merits yet, so we don't know whether we will think it is a hard question one way or the other, because we haven't heard the full presentation and asked our questions.
Mm-hmm. Do we have Ms. Herrick on the line? Perhaps we can ask Ms. Herrick if San Jose was asked, or if San Jose, one, was asked to take the whole matter, and two, whether that's something that they would even consider doing.
Well, I don't know whether the city attorney staff person will be able to speak for the commission.
Perhaps not, but perhaps she can answer the first question at least. Yeah. Unless we know. Does anybody, do you know that?
Elections Commission has to handle it.
Ms. Ng, do you know?
I don't believe so. I believe that it was the San Jose City Attorney's Office that was asked to handle this matter.
The investigation? The investigation,
right.
Yes. Okay.
Okay, thank you. I'm so sorry. Commission, this is Lisa Herrick, and I was asked to review the referral from the Sunshine Ordinance Task Force, and I agree with Mr. Givner that I'm not sure that there is any legal authority under the procedures that your commission has for reviewing these referrals from the Sunshine Ordinance Task Force to refer that to another adjudicatory body completely. It's one thing to have a staff person dual review in place of Ethics Commission staff and perform some sort of analysis based on the proceedings before the task force. I think it's another to send the ultimate decision to another body.
It's actually being transcribed on the screen. Ms. Herrick, thank you for your time, and I have a couple questions about your response. Does that mean, are you aware of whether the San Jose Ethics Commission has ever handled, either on an advisory basis or otherwise, a complaint referral from a different jurisdictional agency?
I have staffed the San Jose Elections Commission since approximately 2008, and we have not ever accepted any such referral.
Has the Elections Commission made any referrals themselves for matters to be handled by an agency outside of San Jose?
The Elections Commission's procedures and I think our ethics ordinance do have some provisions for making referrals, but that's generally in the nature of the district attorney's office or the Fair Political Practices Commission. It would be something consistent with the jurisdiction of the Elections Commission, but might possibly be, there may be, to the extent that there was some criminal activity or some additional allegations that related to some violations of the Political Reform Act, not to another agency like the San Francisco Ethics Commission or the Oakland Ethics Commission.
Okay, thank you very much. Any other questions for Ms. Herrick on this matter?
No, I don't have any.
Commissioner Studley, you had raised this as a potential issue. How would you recommend we proceed?
Well, I'll make a suggestion. I mean, I do find it meaningful that the city attorney reminds us that we have no legal conflict, either individually or collectively. I have no obligation to the executive director. The executive director's obligation is to the commission as a group and to the city and county, not personal. Can understand why we don't ask staff to investigate their supervisor. That makes complete sense. So in trying to, I mean, I wanted to create a window where we didn't just rush pell-mell to do something that thoughtful people were flagging for us. But as I try and deconstruct it, there's a question of legal conflict and of our competence to do it and our responsibility to do it, which is the other point Mr. Givner raised. There's the past practice, the past example involving the deputy director, where we did seek counsel from others so that it wasn't a staff colleague doing the investigation, but this body handled it. And I quite honestly can't remember if I was on at that time, and if so, whether we analyzed this. I came on in 2007, but probably not in time for that item. And I think it is fair for people to put us to our proof, to ask us whether we have both an obligation and the capacity legally to do it, and to ask whether there's a conflict. But I'm actually feeling less room now to do something else. The advisory opinion or some other option, we could listen on the merits and make a judgment at that point whether we want to decide, pause, refer, seek referral, seek an advisory opinion. So given that we have Ms. Herrick and Mr. Shaw here, one possibility would be to proceed and see what the issues are. We may also find there are complicating issues that we want to know more about on the merits as well. That's not sharp and final, but I am actually, what I'm hearing is making me feel that we may have to do it, and there is less reason that we can't do it in terms of the direct, do we have a conflict? We act, with regard to city officials all the time who, where the situation is sensitive and we are all working for the city or, have those kinds of concerns. I haven't heard anything that said why we in particular would be unable to deal on the merits related to a member of the staff.
Commissioner Liu, do you have any thoughts on this?
Well, I think that was a really helpful discussion and helpful from the city attorney's office to get the guidance we did, because I came in thinking, if there's a way to transfer it to another adjudicatory body that might help with perception issues, but if there's no mechanism for doing that, and to be reminded that it is our ultimate responsibility as San Francisco Ethics Commission to adjudicate complaints before us, then I don't really see, like Commissioner Stelly was saying, any room to do otherwise. And then the question of whether we try to seek an advisory opinion from another body is, could be problematic in the sense that, is it basically the same as the mechanism we've laid out here, which is it's investigated by a different body, and we're going to take that that opinion and decide what we want to do with it. So, yeah, I'm seeing less room to transfer these complaints to an entirely different body.
I share that view. I mean, it is an imperfect system. Obviously, when you are adjudicating something that relates to the executive director of the entity, there will be some perceptions of bias, and I think that is clear that there is going to be some perception. The law does provide, though, that even some perception of bias is permissible in a situation like this, where you have no legal conflict and we really don't have other options that would allow us to have someone else adjudicate it. So,
may I comment on that point, please?
I do. You will have that opportunity, Mr. Shaw. So, I'm not sure we have a choice. It doesn't sound like we have a choice, and I don't think an advisory opinion is going to be particularly helpful if we have to re-adjudicate it.
Right. I agree.
I'm not sure that this is. I'm not sure of the weight of this, but as I think about my own universe of nonprofit groups where boards of directors, boards of governors are responsible for making determinations related to the executive directors whom they hire and work with, and conduct business together, that they investigate harassment complaints, whistleblower complaints. They seek outside legal counsel typically to do that if they are well organized, but they handle those because it is their job to do so. And so I raised it because we do want to be careful and thorough, but I think at this point it might make sense to proceed with the hearing from the attorney and Mr. Shaw and public comment, and then decide. At that point, there's no obligation for us to act tonight, and see if we are prepared to do so, or whether there's any part of this that we want to explore further.
Mr. Givner, I do have a question for you. well, Commissioner Studley, I think that's a fine way to proceed, and I would agree that we should move to the merits. Mr. Givner, I have a question for you about the email that Mr. Grossman identified. Mr. Grossman, do you have it?
No, you started to show it to me.
Okay. In form and in substance, I think the email said something like, to St. Croix, can we disclose the excellent analysis? You have it. No, that's okay. You've already read it into the record. I just want Mr. Givner to have it. Thank you, Mr. Grossman. The email obviously reflects my view on Ms. Herrick's analysis. I do think it was excellent. And certainly I had not received or read Mr. Shaw's response, but it did express an opinion as to what I thought would happen with the complaint, and it was directed to Mr. St. Croix. This being a situation where, I mean, Mr. St. Croix is clearly the person I typically deal with when trying to figure out procedural matters and what should be disclosed to the, what should be in the packet and what shouldn't. So I just followed my normal procedure in sharing that with him. Does that create a conflict that should lead me to recuse myself from this matter?
No, it doesn't. It doesn't create a legal conflict or a disqualifying bias that would require you to recuse yourself. It indicates that you reviewed Ms. Herrick's analysis, indicates your views of that analysis. You were, from my reading of it, you were asking Mr. St. Croix whether it could or should be made public, and nothing in the email indicates that you're biased in any way that would prohibit you from participating in this decision.
Do any of my fellow commissioners have a
Can I have it back, please?
Yeah, you can give it back. Issue or questions with my involvement in adjudicating this matter?
I do not, because I think, as Mr. Givner said, it reflects sort of the after the fact, after you've reviewed the analysis, how you felt about it, but it didn't show to me any bias going into reviewing the matter.
Well, if I remember the words correctly, and I wrote them down at the time, it was a question about whether to release the memo, which stands for the proposition that it falls, not that you had made your final determination at that point. So I don't think you were describing or planning a result, simply describing the memo.
Well, what do you think it meant?
I think, Mr. Grossman, please sit down. I had not made a final decision, obviously, given that the matter had not been adjudicated, but clearly I did believe that Ms. Herrick's analysis was right. I will say that on the record. I mean, when I read it, I evaluated, looked at the law and looked at what she said, and I thought it was right. Now, I'm saying that right now. Again, that was before I got Mr. Shaw's response. But I personally don't feel like that disqualifies me from adjudicating this matter, given what the city attorney has said, and in light of the response from my fellow commissioners, I am prepared to continue on. But
I do.
Mr. Shaw, you will get your chance. Okay, I'm telling you, you will. Commissioner Studley, if that changes your view as to whether I should be adjudicated, then I would listen very carefully to your opinion.
All I can say is that in any given moment, I know my own consideration of a matter, whether it's a policy matter or a legal determination, I read a piece, I have a view based on the reading of that piece, I read the other piece from the other side. I read the opposition, I read the reply brief. I read the memo in support and the memo in opposition. I read my ballot initiative, and I think that sounds pretty compelling until I read the other piece, and I say, oh, I didn't think about that yet. Now I need to rethink it. So I think the question is, any commissioner's open mind as to the total set of legal presentation, argument, and public comment that comes before us, and that our obligation is to take that all into account, not whether at any given moment one piece of the evidence that was going to come before us led us to think one way on an issue, or, I think that email is something that I'm glad you opened. I appreciate and respect your doing that, because I think it is useful to have said what it stands for, but I think the legal advice is right, as long as for any of us, we feel we have an open mind on the merits of an issue that's before us. People can judge from the conversation and the analysis and the decision that we make.
Mr. Shaw, I will give you a chance to talk now on whether we should handle the matter issue, which is the preliminary matter, and also the merits, if you would like to so address them.
Okay, thank you, because the miserly advice I received from Mr. Chatfield was that I would only have public comment, not any kind of presentation.
I'm giving you a chance for presentation.
To that extent, I'm shocked that you're rushing this thing through before adopting any final guidelines for referrals of this Sunshine cases. You should be waiting until you hammer out that process instead of catching me at the tail end of an old process that you don't like and you haven't finished the other process. But I find it interesting that DCA Givner said that he was not consulted before this was shipped off to Ms. Herrick in San Jose. Apparently, the commission members themselves didn't know that. Apparently, Mabel Eng didn't know that. Sounds to me, particularly from a phone call I had with Ms. Herrick, that she had a phone conversation with Mr. St. Croix. I find all of this beyond the pale. Mr. Givner says that there's been no past practice about shipping things off to another jurisdiction, but the past practice is sitting just to his left. The case against Mabel Eng went to Oakland. Oakland developed a final recommendation after conducting an analysis and sent it back, and you did rubber stamp that. You have a past precedent of shipping cases to another jurisdiction, despite Mr. Givner's off-the-cuff opinion, which he didn't cite you any opinion number or any memo from the actual city attorney. So I think, from my point of view, it sounds like Mr. Givner is winging it, and that he's offering you his personal opinion, not a legal opinion, and certainly not a legal opinion issued by the city attorney. So I remain concerned on the issue of whether you should even be hearing this case, and I'm not really quite ready to jump into the merits without, some kind of reconsideration. It stinks to high heaven, whether you can see the perception or not, that there is a perception of a conflict of interest in this case. You shouldn't be hearing it. And I shouldn't have found out from Ms. Herrick that she had had a conversation with Mr. St. Croix. Nor did I know that Ms. Herrick was being dragged into this simply to give you a recommendation. I thought that I would be headed towards the San Jose Ethics Commission. but it appears they don't have one. And I am very disturbed that this went to an elections commission, not an ethics commission. It should have been referred to a jurisdiction that has an ethics commission. San Jose doesn't have one, should have went to Oakland. I can't sit here and say that every elections commissioner has been trained even remotely in ethics. I'm not sure that you're required to be trained in ethics before you're appointed, for that matter. You may all have law degrees, or some of you may not. But I don't know that having election staff review an ethics case is really where you want to take this. As for merit, in my September 19th memo, you know, the one that you read after you concluded that she was correct, I note in my memo that Ms. Herrick and the Ethics Commission itself keep stumbling over Section C3.699-13. You lost that case Mr. Grossman brought against you because it was clear that 699-13 only applies to ethics laws, not to public records access laws. And my complaint involved at the Sunshine Task Force and public records access issues, not ethics laws. So starting with Mr. St. Croix and Mr. Massey, who submitted various documents early on in my complaint process, and then the 4-page set of citations that the city controller issued, all focused quite heavily on 699-13, with you all forgetting that that citation doesn't apply to public access records law. And all along the defense in stalling production of the records that I've asked for has hinged on the wrong application of ethics laws to a public records case. It's been noted that a narrow construction of 699-13 compels the conclusion that it applies only to ethics laws.
Mr. Shaw, can I ask you a question about that?
I may defer my answer to Mr. Grossman, who's the expert on this, if you don't mind. Because unlike you, sir, I am not a lawyer.
Okay. My question is, I'm not sure I quite understand. It seems like apples and oranges. I mean, my understanding, let me ask my question and you can answer to the best you can. My understanding is that 699.13 refers to a number of areas that the Ethics Commission has the authority to investigate, such as campaign finance, lobbying, conflicts of interest, and governmental ethics. Doesn't this investigation relate to the Commission's authority to investigate governmental ethics violations?
My complaint alleged that the records I saw between ethics and the city controller on the Laguna Honda Patient Gift Fund were being withheld.
But doesn't the Laguna Honda matter? Why isn't that an investigation relating to governmental ethics?
Because it was an investigation about, I would frame it more that it was elder financial abuse and not ethics. It was a misappropriation of funds it was not per se about ethics. Funds were misappropriated from a restricted use fund and was spent aggrandizing staff. And when the city controller finally was pushed into conducting an audit, $350,000 of that misappropriated funds was restored to patient use. It was more about financial issues, not about ethical issues.
May I ask Mr. Shaw a question?
Sure.
Isn't part of your point that it doesn't matter why you wanted them, that it's simply a public records request and you don't have to tie it to elder financial abuse, or
that's right.
You could have been looking to see what letterhead they used or whether they
Commissioner Studley, you are right. When you file a sunshine complaint, you don't have to specify. Is it public access? Is it ethics laws? You don't have to say why you want it.
Is it sheer curiosity, or do you think something was going wrong, right? You don't have to tie it to. I thought that was part of your point.
The Sunshine Ordinance quite clearly states that records requesters do not have to specify why they are asking for records. You're right.
And I understand that as well. I guess I thought that your argument is that C3.699-13 doesn't apply because this is not a conflict of interest situation.
It's not a conflict. I had not alleged a conflict of interest issue or an ethics issue in my initial 30-page sunshine complaint. And believe me, that 30 pages was because I developed a table and went through the 4 pages of citations that I was first given by the city controller's office, and then as I started objecting to those particular citations, they started rolling out new citations and changing the old citations. But I did not start out on an ethics complaint on this. It was strictly about access to public records. And if the city controller's audit is finished, and assuming that the Ethics Commission's investigation of the patient gift fund is complete, those investigations are complete, and the records have to be released because the investigation is over.
Any other questions for Mr. Shaw? Were there any other substantive points you wanted to make, Mr. Shaw?
Again, 699-13, indicating that investigative records have to be kept confidential, applies only to ethics laws, not public records access laws. Ms. Herrick, for her part, all but ignores Campaign and Government Conduct Code 4.105. 4.105B states, the Ethics Commission shall investigate complaints under this section that allege violations of local campaign finance lobbying, conflicts of interest, and government ethics laws, which Commissioner Hurd pointed out. However, Section 4.105A states that any person can file a complaint with the Ethics Commission alleging that a city officer or employee has engaged in improper activity by, again, violating campaign finance, lobbying, conflicts of interest, or government ethics laws, regulations, or rules. The difference between them is that complaints can be filed under 4.105A, alleging many different violations of improper activities. But under 4.105B, not all of them are investigated pursuant to procedures specified in Charter Section 6.3 C3.699-13. So the whole 63.699-13, in my opinion, is moot. I believe Ms. Herrick may also have wrongly claimed that the California Evidence Code 1040 and its definition of official information may have been misquoted, and she may have incorrectly relied on Deputy City Attorney Jerry Threet's improper letter to the Sunshine Ordinance Task Force, in which he wrongly combined 2 or 3 of Dr. Derek Kerr's complaints into one large ball of wax, wrongly. He shouldn't have done that. Jerry Threet made a mistake when he did that. The key in Section 1040 is not whether disclosure is permitted. It's whether disclosure is forbidden. Jerry Threet made that glaring error. How a deputy city attorney can confound forbidden with permitted. And then Deputy City Attorney Herrick fell into the same soup mix is really disturbing.
Let me ask you about that, Mr. Shaw, because C3.699-13 appears to use the term to the extent permitted by state law.
I draw your attention, Commissioner Herr, to Section 1040B. I'm assuming that state law takes precedence over 699-13. I would assume, sir, that you would know that 1040 should take precedence over the city charters or this particular government conduct code, which isn't even at the city charter level, if I'm right. 1040B clearly states a public entity has a privilege to refuse to disclose official information, ... unless disclosure is forbidden. There is nothing in an act of the U.S. Congress or any other statute that forbids disclosure of the information I am seeking.
I mean, except that there's another paragraph, Mr. Shaw. I mean, the basis for Ms. Herrick's analysis is 1040B2. She's not claiming that there's an act of Congress that forbids this. She's claiming that the necessity for preserving the confidentiality outweighs the necessity for disclosure. And I understand you can have arguments about that, but...
Commissioner Herr, let me respond to that question, okay. And that is, Sunshine Ordinance, if you've ever read it, specifically bars every city and county agency in San Francisco from exerting the official information privilege under that balancing test.
Didn't you just tell me that state law trumps the city charter and all city ordinances? That's, I mean, what you just were arguing 1 minute ago and berating my legal knowledge on the basis that that's how you accurately interpret the law. So, I mean, okay, but you can proceed on whatever additional substantive arguments you have, Mr. Shaw.
Sunshine Ordinance is quite clear. You cannot use that balancing test. Any balancing test, whether it's 1040 or what is it, 6254.7 and .13, you can't use balancing tests, not in San Francisco. I believe somewhere along the line, the Ethics Commission, in their response, which the Sunshine Ordinance Task Force rejected, indicated that the Ethics Commission staff, it indicated, and I believe so did the city controller, that they were withholding based on 6254F. But that doesn't apply to either ethics, our Ethics Commission, or to the City Controller's Office. 6254F says that records of complaints or investigations conducted by or records of intelligence information or security procedures of the Office of the Attorney General and the Department of Justice and any state or local police agency or any investigatory or security files compiled by any other state or local police agency those records can be withheld. But Mr. St. Croix and the Ethics Commission, and the Ethics Commission staff and the City Controller are not police agencies of any sort whatsoever. So their reliance on 6254 is also incorrect.
I agree that we're not a police agency, but one of the questions I had was what the definition of a law enforcement agency is, since we are enforcing a set of laws for which we have a particular responsibility. It doesn't make us a police agency or a correctional agency, but does it make us a law enforcement entity, given our responsibilities to enforce particular laws, some of which have no one else to enforce them? That's a legal question. I'd be interested in hearing from Ms. Herrick on that one.
Certainly. So I would not call the Ethics Commission a law enforcement agency under 6254F. Typically, that it does rely to police agencies, fire departments when they're doing arson investigations, for example, may be law enforcement agencies. But I don't recall seeing anywhere in the materials a reliance on 6254F. I didn't rely on 6254F. There are other state laws that protect disclosure of confidential information. It's Government Code Section 6276 and 6276.32, which are part of the Public Records Act, as well as the Government Code section that the the Controller's Office relies on in terms of the protection of whistleblower complaints, and that's Government Code Section 53087.6. So while I agree with Mr. Minette-Shaw that that reliance on 6254F of the Government Code would not be appropriate, there are other code sections that do protect the disclosure of confidential information, and they've been cited in my memo to the Commission.
Mr. Minette-Shaw, I think you've pretty exhaustively gone through your arguments. I'm going to give you a few more minutes. I've already given you far more than we would give someone if we were using the new procedures.
No,
so
you just dismiss it.
I'm going to give you 3 more minutes, to provide, I think we've already gotten through about page 8 of your arguments that you've explained, so I'll give you a few more minutes to provide
in
the
rebuttal
additional substantive
to
arguments.
Ms. Herrick's comment just now that there are other codes that may be involved, curiously and more curiously, none of those have been mentioned to date. This sounds much like the Ross Marcarini case, in which you first rejected outright all 6 of the amended charges against him, and then you made up a hybrid charge right before the August 19th hearing concluded. Mr. Marcarini had all but a minute and a half to realize he had a new charge against him. And now what Ms. Herrick is indicating is that some other citation, which has never previously been provided to me, is now being used.
I'm pretty sure
It's on page 4 of 17 of her memo that I'm looking at here. The September 6th memo refers to the 2 sections that she just noted.
It was not her position to raise that citation, Commissioner Studley. If anyone wanted to use it, it should have been the city controller or the Ethics Commission. It shouldn't have been an independent, so-called independent reviewer coming up with that citation after the fact. I'm going to repeat myself. I don't believe you should be hearing this case. And I'm asking you again to transfer it to the Oakland Ethics Commission. Thank you.
As a matter of record, I'm not even clear that the Oakland Ethics Commission is operational. I think they've been disbanded or suspended in light of lack of funding. Ms. Herrick, we invite your response, and thank you for being on the phone with us.
Certainly. I'm happy to answer any specific questions. There were other things that Mr. Minette-Shaw pointed out. I think I've responded to the bulk of them. Well, no. Let me say this. There was a question from one of the commissioners, and I apologize since I'm not personally there. I can't track you as well as I could have if I were personally present. But I do. There was a question asked of Mr. Minette-Shaw about isn't the whistleblower, the gift fund whistleblower complaint, isn't that an ethics issue? And that's exactly the way I view it. It is. I mean, you're questioning the use of the gift fund. That's absolutely an ethics issue, and it does come within the charter section C3.699-13A. The other point I would make is that in looking at the records that are protected under that charter section, you're looking at the underlying records, not the basis of the complaint that Mr. Minette-Shaw filed. So although I would, frankly, if the complaint that was being investigated had something to do with public records, honestly, I think that public records, open meetings, those are all governmental transparency laws. I think they all come under the big umbrella of governmental ethics. But the point I'm really making is that because the whistleblower complaint related to an ethics issue, it is that the investigation is protected under that charter section.
Ms. Herrick, I have a question with respect to the application of 1040B2.
Yes.
One thing what do you believe constitutes the necessity for preserving the confidentiality of the information that outweighs the necessity for disclosure in the interest of justice?
Well, from the controller's perspective, obviously they're investigating a whistleblower complaint, and it's in the public agency's best interest to protect whistleblowers. And in fact, I think that there may have been a question or a concern about why can't whistleblowers waive the complaint that they made? Why can't they consent to have their complaint be made public? And the reason why that's protected by state law and not to the individual who makes the whistleblower complaint is there really is a governmental interest in protecting the integrity of complaints that have been made. Any complainant could be subject to pressure to open up a complaint or an investigation, and to the extent that the investigation led to additional witnesses or complainants who provided some information, by opening up the entire complaint and investigation, you're opening up the threat of retaliation to others who may have been involved in the complaint. I mean, I think it's comparable to a criminal investigation and a criminal prosecution. A victim makes a complaint. Many times victims recount what has gone on, but just because a victim says, I don't want to testify, doesn't mean that the case against the defendant won't go forward. It may be more difficult for the prosecution to prove their case without the victim being a willing, providing willing testimony, but it doesn't mean that the complaint goes away against the defendant. And there's an interest in protecting the integrity of those sorts of proceedings.
Ms. Herrick, can I ask you a question about that?
Sure.
So are you making a distinction between, on this waiver issue, if a complainant waives, their own complaint as opposed to disclosure of the entire file, disclosure of just the complaint itself that was made by the complainant versus disclosure of the entire file? Because from my review of the materials, it looks like the request was for entire files of information, not just the complaint itself. Is there a distinction to be made there with respect to waiver?
That's a fair question. I would still say no. I wouldn't make that distinction because for the reasons where the same sort of, when you have a potential whistleblower subject to some pressure to provide a waiver, you don't know whether or not that's been willing or not. By removing the ability of the whistleblower to make that kind of a waiver protects I think the integrity of the process is better protected.
Okay, thank you.
Any other questions for Ms. Herrick at this time? Ms. Herrick, what about this idea that a evaluation under 1040B2 has to be made on a document-by-document basis? What is your view on that?
Well, I think that we are making it on a. I mean, is it a document by document, every single piece of paper within the file? No. But loosely, we're saying, does official information apply to the file that we're talking about, the file before the Ethics Commission, the file in the possession of the Controller's Office, and the communications between those two offices? I think you are taking it on a case-by-case basis. I don't think that the section requires a paper-by-paper review. If I were to say that every single piece of paper within the Controller's Office or the Ethics Commission is official information, I don't think that's true. I think you would say no. Correspondence is not. Agendas of the Ethics Commission, that's certainly not necessarily protected by the official information privilege. I can think of a lot of other day-to-day operational business of the offices that is a public record, not necessarily official information. So I think you are making that analysis on a case-by-case basis. This is a file in a whistleblower complaint, and then an investigation by the Ethics Commission as well, and those files they contain official information.
So basically your point is that there's sufficient specificity to apply 1040B2 to the entire investigative file.
That's right. Because I'm not saying that the I mean, there are just myriad other documents. For example, the Controller's Office produces, I don't know if they did in this particular investigation, but in other audits that the Controller's Office may do, they will come up with a summary conclusion, an audit report. That's a public record. That wouldn't be something that's official information protected by that particular privilege. So there's plenty of other work produced by both of those offices that are public records and not subject to the official information privilege.
Any other questions for Ms. Herrick? Ms. Herrick, would you mind staying on the line?
Sure.
I think we should take public comment on this matter.
I would like a 1-minute rebuttal to Ms. Herrick, please. I promise to keep it very short.
Okay, Mr. Shaw, I'll give you that.
So, what Ms. Herrick may have missed and what you may have missed is when Dr. Kerr's complaint came before the Ethics Commission and was submitted to ethics staff, you guys sat on it for 6 months. And after those 6 months, you then rejected that case, and you sent it right over to the city controller's office, who finally got off their rear end and conducted an audit after you said you would not take jurisdiction over it.
Your point being? I'm truly just trying to understand what the consequence of that is.
I just find it quite strange that you first rejected any jurisdiction of this case at all, and now you're quibbling over what sections of the file are releasable and which aren't. If the matter is closed, any correspondence related to this complaint is not confidential. And that's part and parcel of what I asked for.
Public comment.
I'll try to make this brief. The letter to Ms. Herrick in May said, Ethics Commission regularly per your conversation with John St. Croix, that's important. The Ethics Commission regularly handled referrals, however, it cannot adjudicate these matters as the executive director is a named respondent in both complaints. What are we doing? We are adjudicating it as we speak. The second thing is, I think you can't vote. I think your vote would be tainted in view of your email. I think you're missing 2 of the 5 commissioners. You will not have enough people. You need 3, and you, in my view, should not be voting on this. I say that with, believe me, an enormous respect for you personally and what you are doing and what you did in the Barkarimi case. But I do think there's so much misinformation about what the law is under the Sunshine rules, what's involved in the Public Records Act, and actually there is constitutional provisions regarding the very thing that you're doing, which is interpreting a law in a public access case. Having said that, there was no hearing by Ms. Herrick. She didn't hear anybody representing Mr. Shaw And if there had been a hearing, I might have shown up, and some of these other folks might have shown up and given her some other ideas about how to go about this. But this was all prearranged. You didn't know it was going down there. There's nothing in the file that indicate that this body made a decision. We can't send it to Oakland because they're a bunch of losers, or we can't send it to Berkeley because they're a bunch of losers. We will send it to not to the Elections Commission, but to a lawyer who works, I'm sure, in much the same way that the city attorney works, which is to defend the bureaucracy. So in my view, it's a mistake for you to even try to adjudicate it today without getting an opinion that you can do it. And most of the stuff is off the cuff. I would suggest that Ms. Herrick look at the difference between government campaign and government conduct code sections 4.105B and 105A, because they demonstrate that there is a difference between a complaint filed with you and a complaint that you are entitled to investigate under C 3.699-13. I actually have a bunch of other points, but in view of the fact that my 3 minutes are up, I guess I can't make them. I'm the only lawyer on this side. Thank you.
Thank you, Mr. Grossman.
David Pilpel, I'll try to be brief. There are a number of issues at play here. I was not a member of the Sunshine Ordinance Task Force at the time that this matter was heard and referred. I'm relying primarily on the memos from Ms. Herrick and some of the collateral materials that I've seen. I thought that this was a fairly straightforward matter, but I believe that it's actually more complicated than I initially thought. I do believe that the Commission is the proper place to air this and to make it a decision. I don't believe that it needs to go to any further outside body, and I generally concur, or I believe I do concur, with Mr. Givner's analysis that under the Charter only the Ethics Commission can make a final determination, even if some other body provided review and analysis. I think that Mr. Monette-Shaw was largely correct on the question of applicability of the balancing test in San Francisco under the Sunshine Ordinance and its incorporation of state law with some exceptions. I'm looking very carefully, though, at the summary of the complaints in the two memos from Ms. Herrick, and it seems to me that the extent to which there is an investigatory file either at the city controller's office or that the Commission has conducted an investigation, that those investigations are probably not subject to disclosure, but the scope of the initial or underlying request for any and all written correspondence between the offices related to the complaint seems to me to suggest a body of material that's beyond the investigatory file itself and may include correspondence about the handling or the procedural aspects of the investigation and not the file itself. And to the extent that any such records might exist, they, to me, to my read, might be subject to disclosure, albeit in a redacted form. I don't know if they exist, but that's my view on that. With regard to any closing memo, if there was, I don't know what the language of a closing memo authored by Commission staff regarding this complaint refers to, but again, if such a thing exists, if it's not otherwise made confidential, and I need to analyze that further, I would think that it may be subject to disclosure, albeit in a redacted form. The question, though, before you isn't whether these documents can be ordered disclosed, it's whether these officials have committed a violation of the ordinance, and that is itself wrapped up into this analysis. And I'm sorry I can't help you any further. I hope that does something to help. Thanks.
Commissioners, Ray Hartz, Director, San Francisco Open Government. Now that this Ethics Committee is holding meetings on SFG TV in full view of the public, it becomes more apparent how much of an enabler this body has been. It enables city bodies and personnel to evade their duties under the law and to hide that evasion from public scrutiny. In these cases, the whistleblower protections are not being used to protect the whistleblower, but to protect their targets. They are being used to hide from the public the true facts of the investigation, to allow city agencies and their employees to evade accountability for their actions. They hide from the public the extent and validity of the investigative process used by the ethics staff. Public records laws are always intended to disclose rather than conceal public matters. Instead, these laws are being purposefully misinterpreted to protect not only the agencies in question, but also the Ethics Commission staff. Now, as far as you not having a conflict of interest, let's look at the Arts Commission when they got the report from the civil grand jury that just listed myriad things they had done, including spending almost $300,000 on programs they had no legal authority to do so, charging fees to bodies that they had no legal authority to do so. They had to fire the cultural director, and they also had to replace the head of the commission. The bottom line is, if you are a commission and you are in charge of a staff and the staff screws up, it reflects on you. You can't sit there and say, oh, if we find our executive director in violation, that has no reflection on us at all. Even though we turn over 99% of what we do to them, and in cases like mine, Mr. St. Croix has a complaint against him, and he gets to dismiss it on his own authority. And you don't call that some sort of a conflict of interest? The bottom line is you're here to ensure that this process is an open process and a fair process. I've heard a number of things here that I find totally disconcerting. Apparently Ms. Herrick got her directions on this complaint from Mr. St. Croix or your staff. She's had conversations with Mr. St. Croix and the staff. I've watched you, a lawyer, sit here and argue with Mr. Minette Shaw, who is not a lawyer, which puts him at a totally unfair disadvantage. And you see no problem with that. Asking him legal questions and expecting him off the cuff to provide legal responses. And instead of being somewhat fair and saying, well, since Mr. Grossman is here and he is an attorney, let him speak to some of these issues and answer your questions, you would rather let it be Mr. Shaw, who can't, in your knowledge, answer those questions so that you have a justification for doing what you want to do. The bottom line is, if you find Mr. St. Croix innocent, you're simply clearing your own name. If you find him guilty, you're finding yourself guilty, because delegation is not abdication.
Said that Grossman couldn't talk.
Good evening, Dr. Derek Kerr again. One of the things that prompted Mr. Minette Shaw's request was the fact that retaliation had already occurred against the two whistleblowers who reported the misappropriations from the gift fund. So I understand the theoretical concept of protecting whistleblowers in the future and in general by keeping things confidential. But it doesn't work in reality, you see. Now, if you contact the FBI and ask for information about a closed case, they will tell you that how they investigated, the process is confidential, some of the information is confidential, but they will still send you the file. Sometimes it will be completely blackened out, but you know that there's something. But here with ethics and with the controller's program, the investigations are non-existent. But the retaliation occurs while no investigation goes on for 2 years. Well, 2 years and 2 months. In this case, it's closed. It's a closed case. Ethics said it's not in their jurisdiction. We gave permission to disclose whatever was disclosable, and the least they could do is disclose redacted documents, just like the FBI does. And then we would know, at least, that there was a document.
Good evening, everybody. The Giants are winning. So let's stick with what's real here. Because some of this stuff that we're dealing with is like down the rabbit hole with Alice, you know. So, and those of you on the commission who are here, I note there are only 3. You know me. My name is Paul Currier, and I'm passionate about open government, and I'm passionate about things being done by the book. And when you have people like the district attorney and the mayor who are committing wholesale felonies, I really believe they need to be prosecuted. And I don't know if this is the forum for that, but this is the forum to discuss things like the integrity of the process. And this is the forum to discuss things like whether the Ethics Commission itself has a conflict of interest in this matter with Patrick Minet-Shaw. I strongly urge that if the Ethics Commission feels they have no conflict of interest hearing a case against their executive director, all 3 of you need to seek professional help. I'm serious about that. Because the conflict of interest, I believe, is clear to anybody with an 8th grade education or above in San Francisco that's watching this drama on TV. Now, the reality of the fact...
Given what else is going on today, I doubt you have much of an audience.
And we don't have much of an audience today, and thanks to God that SF.gov TV does do instant replays. Not instant, but we'll go through that later. Thanks for taking some of my time. I did want to discuss the concept of due process. And I did want to discuss the idea that the constitutional provisions for due process apply. And it is completely appropriate. In fact, it's the ethical thing to do for this Ethics Commission to send this case over to Berkeley's Ethics Commission, because at least they're hearing cases and they don't have bias built in. It's unfair for sitting members of the Sunshine Task Force to have ongoing conversations with the director of the Ethics Commission. When Mr. Pilpel is doing that in these rooms, this type of conflict of interest that's built into the collusion between different city agencies, it's absolutely off the hook. Since 1999, Willie Brown issued orders to every one of his departments and commissions not to comply with Sunshine. I've been doing immediate disclosure requests across the departments in San Francisco. None of the department heads have done the Form 700s and the Sunshine certifications required by law. The whole city is out of order, to quote Al Pacino, and go Giants.
Hi there, Dr. Maria Rivero again. I was one of the 2 whistleblowers, and from my perspective, what I'm asking for is actually not confidential investigatory information. What we wanted to know about was whether there was an administrative memo during the time that the Ethics Commission sat on our case for 6 months while the 2 of us were driven out of Laguna Honda, ordering the whistleblower program not to concurrently investigate the case. And in theory, according to your rules, the Ethics Commission should have sent a written memo to the whistleblower program, or the whistleblower program should have carried on a concurrent investigation, but they didn't. So we'd like to see that memo. And again, it's not a matter of idle curiosity. We served the city for 43 years between the 2 of us, and then we were summarily removed after blowing the whistle. Thank you very much.
Hi, I just want to bring your attention again to the fact that I sat through all of these hearings, every single one of them, and the memo that is from the San Jose City Attorney is not detailed in our discussions. David Pilpel and I agree on almost nothing. And he has extensive experience with that Sunshine Ordinance, and he sat on the task force before, and he's been through many, many origins of it. And he brought to your attention again the same thing that we discussed, that there is some correspondence in there that doesn't fall under the investigatory process that the city claims everything is under there. And indeed, Dr. Kerr brought up again that in some instances, they just wanted to know if anything had even been done. They wanted some dates. There was money that was found indeed to be missing, and it was replaced. And the people who found it to be missing, we have no idea what happened to them, but the doctors who found that it was missing are wanting to find out some pieces of information because they were retaliated against, or they believe they were retaliated against. So just two very different people from the Sunshine Ordinance Task Force who sat through many hearings are just describing to you that the law may not have been applied incorrectly to all the pieces of information here. Thank you.
Good evening, everyone. My name is Lynn Gavin, and I'm here because I'm disturbed by what happened to the doctors. As someone who's worked in the health insurance field, it's very difficult to get very good doctors. And thinking about the people at Laguna Honda, for them to have been taken away, and thinking of the age group of the patients at Laguna Honda, I think this is something that many people may not be aware of that has adversely impacted the patients, because it means a lot to seniors to really have a good doctor because they know that they have someone that listens to them. I'm equally disturbed because they were dismissed for doing the right thing. And it's just unbelievable at this day and age that we are going through this, but we have to go through this. I think that if this is a conflict of interest, and I think that it is, I think that this case really should be referred out. I think that for your own integrity and for your own self-respect, and you are an important body. Granted, we may not always agree with you, but you are all educated. And I can understand there are unseen forces that may be behind you, but for your own integrity and your own self-respect, I would ask that you do the right thing and that you refer this case out and not try to make a decision that involves the executive director, because that is a conflict of interest, even though you may think it isn't, but I really think that it is a conflict of interest, and a lot of other people would think so too. Thank you.
Discussion among the commissioners regarding this matter.
If Ms. Herrick is still on the line, can I ask her a question?
Sure, of course. Ms. Herrick, are you still there?
I am.
Okay, thank you, Ms. Herrick. Can you talk a little bit about or respond to some of the comments we've heard about whether there's a distinction, whether there could be a category of correspondence that is not swept up under the exemption from disclosure? And this, I think, is in particular to reference to complaint number 0816 with respect to the Controller's Office, the correspondence between the Controller's Office and the Ethics Commission.
Yes, yes. So they're not having access to the file. I think that there possibly could be. I don't know. I thought in reviewing the file that there had been some information that was provided to Mr. Minette-Shaw, but I could imagine that there might be some information that would not fall within the exemptions that we've discussed. But I would have to go through that on a document by document basis. But it's possible.
Okay, thank you.
Sure. I don't mean to intrude. If the Commission is interested in hearing about my conversation with Mr. St. Croix, I'd be happy to explain that as well. There have been a few references to that.
Sure.
Okay. Mr. St. Croix called me in May and said, I am conflicted. This is something that the staff of the Ethics Commission typically does. Would you be interested? And I said, And then I said, let me talk to my supervisor. I talked to our city attorney. He said, do you have time to do this? I said, no, not really, but I believe in karma, so the right thing to do is to help out a fellow commission in the Bay Area. And so that was really, I called him back and said, I will do this. And then Mr. Chatfield sent me the file, and then any other logistical conversations that I had with Mr. Chatfield or about this hearing was with Mr. Chatfield and not Mr. St. Croix. But it's been purely logistical or procedural. We have had no substantive conversations about the referral from the task force or my recommendations.
Any other questions for Ms. Herrick?
No.
Comments from the commissioners on this matter?
Well, I mean, I would hate to prolong the matter, but I do think if there could be correspondence that might not fall under the exemption, that should be examined, whether there's correspondence that's responsive to the request that hasn't been turned over.
Commissioner Studley, any views?
I agree. I think that could be helpful. With respect to the timing, Commissioner Liu commented about prolonging. For the most part, I am torn between what we hear urging us to act on the matters that come before us related to Sunshine Task Force and the recommendation that we put them all off until a time uncertain when we can act on the regulations related to how we hear them. So I think we are left to decide what pace makes sense, and with regard to this one, I think we should be thorough, and that Commissioner Liu and this discussion have identified that there sounds like there's something worth having an additional look at. I am still, I think that is a point that is worth pursuing with respect to the additional documents, and would recommend that we hold this over. I think there also a fuller representation of the Commission would be helpful. Can use all the minds available on this one.
This has been held over already once. It has been pending a long time. I think we should decide what we can decide. If we have some concerns about potential communications between ethics and the city controller's office regarding the complaint, that there may be some disclosable documents, then that may be something we could leave open. But if we are clear on the investigative file and the closing memo, then I think we should decide that. I just think if we're going to have to decide it, having gone through this exercise with Ms. Herrick, I do think we should bring as much of it, we should decide as much of it as we can. Ms. Lediju, I see you here. Do you have any knowledge of, I guess, first of all, do you have anything you want to say? We haven't given you an opportunity to do that. And specifically, do you know the...
That's what our attorney Herrick stated. While she's correct, she needs to review our process, and she can't make that determination. She doesn't know our process. And everything under our whistleblower program is confidential. It is maintained within the file of each complainant. Therefore, we don't release that information. I'm not at liberty to talk about our complaints to you or anyone else as it relates openly. So therefore, we have responded appropriately as requested for the request that Mr. Monet Shaw has made. We are not able to provide any information, as we have stated, to the task force, and therefore the information as we stated and as she has stated in law is that we cannot disclose any information. We have none to disclose. And yes, I've heard the task force ask us, we'll redact it. No, we don't. We haven't redacted anything. If something is even requested of us from the judge, there are a lot of things that go in place that are handled by our city attorneys, where it is confidential, where it is closed, so forth and on. So we have been very forthright in our responses to the task force committee, to Patrick Monet Shaw, and to you as the ethics committee. And we have nothing that we can disclose. It's all a part of our file.
How much correspondence is there between the City Controller's Office and the Ethics Commission regarding this complaint?
I can't respond to that.
You can't tell me the volume?
The volume, so my question would be, what difference does that make? And with all due respect, just simply because I myself need to be very careful what I say about any of the cases. And so the point in cases, I think we have the appropriate type of conversations that we're supposed to have as it relates to ensuring that we don't have duplicate efforts going on within the city between the Ethics Commission and ourselves, and ensuring that if one entity is investigating, we're not investigating, and we provide the necessary information if we receive the complaint or if your commission has the complaint.
Is it your position you can't tell me roughly the volume of communications?
No. Yes, it is.
Or whether there is a file at all.
Or whether...
Do you have like a file that's just correspondence that's not...
As I stated before, with all due respect to each of you, and I think you could interject, our work is confidential. We do work with your investigators very closely, and we have worked with them very closely. And I just really need to leave it in that way because there are lots of other things surrounding this information.
Mr. Givner, is that the correct interpretation of the law, that we can't even disclose publicly the volume of any correspondence between ethics and the Controller's Office?
You know, I would say that the fact of correspondence and whether there was one letter or multiple letters as part of that file should remain confidential as well. But my understanding, and maybe Ms. Herrick can correct me if I'm wrong, is that as part of the investigation, Ms. Herrick was able to gather whatever materials were available in order to ensure that the law was appropriately followed.
Ms. Herrick, is that correct?
I did not review the file that exists in the Controller's Office or at the Ethics Commission. Having said that, I have a bold suggestion, which would be that sort of a compromise position that the Commission might take, which is to perhaps direct might be too strong of a word, but ask both the Ethics Commission and the Controller's Office to re-review their files and disclose anything that isn't protected by the law that we've discussed tonight, and if there is anything that they have there has been some oversight of, to produce that to Mr. Manette Shaw.
I have another question while you think about that. I think I understand the stage of things. Ms. Lediju, can a person who initiates a whistleblower complaint or file waive the confidentiality protections, or do those go to the Comptroller's Office in the whistleblower process regardless of the preferences of the individual.
Sure, anyone can waive their rights, but because you waive your rights does not give me the authority or the right to release information, because everyone who is involved in that case, outside of potentially the whistleblower, whoever is part of that investigation is afforded those same protections. And because of that, it doesn't matter that a whistleblower has waived their rights, because everyone is afforded that protection. Therefore, it's confidential.
So a person who, if I filed a whistleblower complaint, I could take my letter and give it to anybody I wanted. But you could not take, your understanding is that you could not take the one that was in your file and give it to a requester or another agency or another party unless it was determined by law or by a judge that the circumstances required that you do so.
Correct. And we work very closely with our attorneys. And again, there's very little, I can say it with all due respect, not to disrespect.
Yeah, no, I appreciate that.
Ms. Herrick, would you be willing to review the correspondence? I mean, is that even a possibility? Because you won't even release it to her to review. Is that the issue?
Yeah, I don't know how those agencies could review it to me either.
If you were to provide guidance on it, what specific guidance would you provide for someone reviewing the correspondence to see whether it was privileged or not?
Well, I am hearing from the Controller's Office that the policy and the legal guidance that they get is that that once a file is opened, everything goes into that file and it is confidential. And I respect that perspective. I'm not disagreeing with that. I don't know if there is any conclusory report that is generated that might be a public document, or to the extent that there are some purely logistical or procedural memos or correspondence. I think memo probably not. Correspondence perhaps. I guess that's the sort of guidance I would give, but I don't want to, I certainly don't want to suggest that the way that the Controller's Office handles their files and or the advice that the City Attorney's Office is providing to the Controller's Office is not appropriate. I'm really talking purely abstractly.
So in your view, Ms. Herrick, would correspondence in the file saying, let's meet at 3 o'clock to talk about this, be confidential?
How about if I say, let me tell you how I handle files in the City of San Jose. I typically an email or a letter memo, any communication that talks about when we're going to meet would be procedural. Having said that, who I sent that to is kind of gives a roadmap to the investigation. Whether I sent it to A, B, and C, but not to D and E, I think is something that is important to the background of the investigation, and it would be something that I would think should be protected.
Basically, you're saying the identity of who you're interviewing, the individuals or witnesses you're interviewing, that's if the correspondence revealed that, you would not disclose that.
Absolutely.
Right.
And there may be other information too. I mean, we're speaking abstractly, so I'm doing the best I can, but I think that yes, absolutely. The identity of anyone the Comptroller's Office was communicating with or not communicating with during the course of the investigation should be protected as confidential.
I guess I'm trying to understand what kind of information could theoretically be in the file that if we asked the Comptroller's Office and the Ethics Commission to re-review for potentially non-privileged documents, what those could even entail. Because the breadth of this privilege appears so broad, it's hard to imagine what would not be covered in light of yours and the City Attorney of San Francisco's description.
Sure. Maybe internal communications about we're going to meet to discuss this at such and such time. So I don't know if who's assigned to the investigation, if that necessarily would be confidential, or how many people are assigned. I don't know if that would be disclosing too much. I would want to, I certainly would think that the Comptroller's Office would want to explain why it should not be disclosed.
Any other thoughts from the commissioners on this? Ms. Lediju, in a theoretical file, not the one at issue, are matters such as the timing of meetings or strictly procedural matters included in the correspondence file of an investigatory matter?
It's generally strictly procedural.
So,
and for example, when you talk about a meeting time, that's embedded within the procedure process. For instance, if I'm going to meet with a complainant and you document your notes, I met with this complainant at this time, here's what we discussed. So you would see it in
okay,
that kind of
that I think clearly would be confidential. But what I'm asking about is, if you send an email to the Ethics Commission saying, can we talk at 2 o'clock, is that in the file?
No, you're not going to see can we talk at 2 o'clock. You'll see the results of that conversation. We met at, and we discussed, because it's a form of record keeping or an interview record, if you will, a discussion record. You have to, one thing that I'd like to say, from an audit investigation perspective, we're very procedural. We're very methodical in documenting our conversations, what we're discussing, time of meeting, those types of things, because I don't want you to think that I'm trying to evade what you're asking me. It's very methodical. And from an audit background, we have generally accepted accounting auditing principles that we follow that help us in terms of documenting, so that we're supporting our outcomes or the reports that we write. So it's very methodical.
Are there documents or procedures that explain to you and to the Comptroller's Office what documents should be kept in the file and what should not?
I don't know if we're that explicit in our manual. We have a manual.
Generally, what is the delineation between, okay, this is correspondence that needs to go in the file, here's correspondence on the other side that is just identifying what time to do the call, and that's not going in the file?
So again, as I stated, you will find in the audit world, in the investigation world, you're not having, those kinds of conversations are not just noted as general conversations, because they become a part of your interview process, your record process, when you're doing your work, especially on the whistleblower side, in the investigation side of the house. And even with our audits, yes, we set up meetings. But again, those meetings are recorded in a very formal manner when we're interviewing, when we're documenting procedures and processes, and they become a part of the record of your work.
Have you reviewed this particular file for
Yes,
potentially non-privileged information that could be
I am
disclosed?
very familiar with the files of our whistleblower program.
But this specific file, have you reviewed for
I'm very aware of-
non-privileged information?
Yes, I'm very aware of the file. We have spent a lot of time regarding our files.
Okay, I understand you spent a lot of time regarding the files in general, but for
No,
this,
I'm saying we've
for this
spent a-
specific case you have as
we
well.
have spent a lot of time on the files.
Okay. I mean, in light of that representation, it's unclear to me what benefit's going to be derived from asking her to redo what has already been apparently closely done. And there's no mechanism that we can provide to ensure any greater accuracy. It's not like there's an in-camera review procedure or something. So I'm not sure what benefit is derived from asking her to go back and re-review the documents.
So are you saying that all of the notes, all the documents in the file for this particular matter is substantive in nature in the sense that it reveals notes and not?
So what I'll say to you in general, everything in that file is confidential.
But I guess my question is everything in the file reflective of notes that, like you were just describing to Chair Her, that there are notes of meetings or notes of interviews with witnesses and so on and so forth? Is that what you're saying?
So again, with all due respect, everything in the file is confidential.
Okay, but that is not a response to the question. She's asking you a specific question about, and you can answer no if that's the case, but I think she's entitled to a direct answer to the question.
Thank you, Chair Her. Yeah, and the reason I'm asking it is because based on Ms. Herrick's memo, what's confidential are drafts, notes, preliminary reports, and so I'm trying to figure out if is that what your representation is, that everything in the file is a form of notes. And I thought that's what you were saying to Chair Her, but so I'm not clear now from your answer.
Everything in the file is a record of our investigation.
But records of your interviews with witnesses, is that what you mean, and your analysis and your thoughts about?
So everything in the file is everything records the investigation that we have conducted and within our files. And I know it's I apologize, and it's not to elude you, but the point in case is everything there represents the investigation that has occurred through our process. And we've carefully conducted that investigation and documented it.
And when you say investigation, what do you mean by that? You mean your interviews with witnesses or in your analysis, or what exactly do you mean by your investigation?
So the point in case is, I don't know if you can speak up, because again, from our, as it relates, so just as, I guess I'll put it like this, just as our Charter F speaks to everything in there as it relates to any interviews, any notes that we take are documented properly within our files.
Right, and is there anything else that's not that?
No, there's not.
Okay, and I think that's really all that I was asking.
I have a different question. It's for Mr. Givner, although if you could wait just a moment, we may have others for you. I'm not sure who to ask, so let me start with you, and you may have another approach. The request that is at issue here was for any and all, was to two entities for any and all written communications between the Ethics Commission and the City Comptroller's Office regarding the complaint in the Ethics Commission file. And any closing memos authored by the Ethics Commission. So we've been asking about the records kept by the Comptroller's Office, and that the answers we're getting are once they are in that file, they have a very heightened confidentiality standard. So I'm inclined to ask the same questions about documents that are in the possession of the Ethics Commission. And for obvious reasons, I don't want to put staff on the spot, but since Ms. Herrick did not, well, so I guess a first question is, could Ms. Herrick see the Ethics Commission files? I understand that Ms. Lediju, am I saying that right? Does not, understands that the whistleblower files at the Comptroller's Office would not be available. So I'll get you off the hook. Ms. Herrick, could you or did you review the ethics files? And maybe you know the answer to that as well. Anybody?
I don't know the answer to, it sounds like the answer to that is no, but I'll let Ms. Herrick speak to it. But I could answer your question more generally, okay. Commissioner Studley. I don't advise the whistleblower program on Sunshine issues. There's other lawyers in my office who do that, nor am I intimately familiar with their process for reviewing files in response to Sunshine requests. Our advice to the Ethics Commission when they receive a request for materials related to a complaint that involves conflicts, lobbying, campaign finance, governmental ethics, is to review the entire file and determine whether any documents in it must be disclosed under state law. And that's what the Ethics Commission does. So I hope that answers part of your question. The second part, and maybe this responds, is that when the Ethics Commission investigates allegations of Sunshine allegations involving other departments, they may, depending on the discretion of the investigator, seek to review the documents that were not disclosed in order to determine what to do in how to proceed in their investigation. I think in this case, Ms. Herrick could seek to review the files of the Ethics Commission to determine whether those files are documents that must be disclosed under state law. I can't speak to the whistleblower program or.
Ms. Herrick, did you review the documents in the possession or maintained by the Ethics Commission related to this matter?
I did not. And just to respond to all of your questions, we did talk a bit about Appendix C3.699-13A of the city charter, which does make those records confidential. And consistent with any advice that we would get from the San Francisco City Attorney's Office about that, I would be happy to review whatever is available. I just would not want to compromise the confidential nature of those records being a third party and reviewing them. So I would be happy to do whatever is appropriate, but under the law, I would be concerned about compromising the confidentiality of a record that is protected by the city charter section.
Mr. Givner, would that compromise the confidentiality of the documents?
I don't think so. You know, when the Ethics Commission's investigators, and jump in here if I'm misrepresenting what you do, when the Ethics Commission's investigators review files of other departments in furtherance of their investigations, they may just go to the department and review the file rather than duplicating the file. I don't know whether that's practical in this case.
Is Ms. Herrick acting as our attorney on this in a way that we could formalize in order to allow her to review the documents without breaching the confidentiality, if that is indeed the protection they're entitled to? I'm talking again about the Ethics Commission documents.
Ms. Herrick is not acting as your attorney in this matter. She's acting in the role, she's stepping into the shoes of the executive director. Okay. Right. If you want, I mean, I'd be happy to look into the question that you've asked. I don't think I can really answer it definitively on the fly.
I just have one more question for Ms. Herrick. So, Ms. Herrick, one more question for you is, what was your understanding, or did you have some kind of understanding of what was meant by a closing memo authored by the Ethics Commission? Is that
that's the way the request is framed, so I think that's why we're talking about it. I don't know if such a thing exists in practice. It may or may not, but that's the way the request is phrased, and so I think maybe that question might be better directed towards Mr. Minette Shaw.
Right, but I mean, in terms of your analysis that you grouped it in as part of the investigation file because it related to, the request was for a closing memo regarding a particular complaint.
Yes, I'm sorry. Yeah, I'm sorry. I understand your question, yes.
Okay, thank you. That's
Sorry
what I
about
thought.
that. So to the extent that the memo is something that was intended to be public, then I think it would be a public record. Otherwise, if it were not intended to be public and it is an accumulation or a summary of information that would otherwise be considered confidential and not disclosable under the city charter, then it would be protected by the city charter as well. So I don't know whether or not the Ethics Commission ever prepares a closing memo that is something that is released to the public or not.
No, I don't think there has been any such memo. Not that I've seen. Okay, I mean, I think our options are this. We can vote on a motion to make a finding as to the executive director and Ms. Lediju's conduct. We can make a motion with respect to part of the documents that are at issue, or we can hold it over entirely. I must say, given how much time we've devoted to it, it does strike me as inefficient to hold the whole thing over entirely. I don't think there's any better mechanism to get to the controller's documents. Now, I may have my own personal views about the breadth of that privilege and how little we can even be made aware of about the scope of the documents. But if that's the law and if that's what the city attorney is going to tell us is the law, then it's hard to suggest otherwise. With respect to the Ethics Commission's files, again, I mean, it appears that we have gone through the procedure of evaluating whether there are such non-privileged communications. The file does, I think, clearly under the law appear to be protected. Whether or not we want to ask and whether or not Ms. Herrick is willing to review the Ethics Commission file to determine whether there are some non-privileged communications, I would be open to discussion about that. As a legal matter, I don't think it's a close call with respect to the investigative file.
Right. No, I would agree with that. So the only question is whether in her review, whether she should actually, if we're going to ask her to review the file to see whether there are any non-privileged documents. I agree that with respect to the analysis, it's sound, and that would be, I think the documents would be privileged, and there's another question about whether someone should actually review it to see if there's anything that was non-privileged that should have been turned over.
Yeah, basically correspondence between the two
Correct.
entities.
Right.
So are you inviting a motion with respect to the Comptroller's Office documents to wrap that up, and the possibility of a further review, a re-review of the ethics documents?
My suggestion, I mean, if we're going to limit it, if we're not going to make a motion on the entire matter, my recommendation would be to find that both the Commission and the Controller's Office, that with respect to anything in the investigative file, that they did not commit a violation or that they did not commit official misconduct for failing to follow the ordinance, carving out only correspondence that the Ethics Commission had with the Controller's Office for Ms. Herrick to review. I mean, the entire investigative file, I don't think she needs to review, given how, given the protections that are clearly afforded to that file. I mean, to the extent there's correspondence, however, between the entities, I could imagine non-privileged communications existing, and that's what I would want to be re-reviewed to the extent we were going to ask for that.
Yes, I would agree with that approach.
Commissioner Studley, do you have a view?
I think that sounds reasonable. Tempted to ask whether it would be okay to ask Ms. Johnson a question, since she. Ms. Johnson?
Sure.
Ms. Johnson, could I ask you a question? Since you particularly focused on, in a attention-getting way, your comment that some correspondence doesn't fall within the investigative process, does this sound like the kind of suggestion to re-review that you were making?
Well, yes, if you're talking about what you were discussing, you're having almost the exact same discussion that we had, because say you had an email that the Controller's Office said, we received, or not even we received, but whatever their procedure is for distributing a piece of information, I don't understand. I understand that they're saying they don't do redactions, but I'm a paralegal. I do redactions all day long, and that some of that is related to why would the date that the Controller's Office took something in be privileged? Why would that be part of the investigation, that there was a date that this was taken in? So if there was, I don't know what their procedure is, but if there was some kind of an email or something, everything within it may be privileged. But the Ethics Commission sending it over to making the decision that it goes to the Controller's Office, or if it's just received, that doesn't seem like it would be privilege. There would be no knowledge of what it was. And I'll remind you again that at the time this came to us, Arnold Schwarzenegger posted names, dates, and accusations online. Now, I'm not saying, I mean, maybe he broke the law, I don't know, but I'm just pointing out that it's a policy decision. And so I think legally there's some question as to whether internal memos of where they go is part of an investigation. I mean, it's procedural, if that makes sense. That they're.
I have a thought here. What I would propose is we make a finding based on what we know that neither Mr. St. Croix nor Ms. Lediju have committed a willful violation of the Sunshine Ordinance. I think we should ask if Ms. Herrick will do so, and we've asked a lot of her already, to review the Ethics Commission's correspondence with the City Controller's Office. If she finds any correspondence that is not privileged, I think that I will specially set a hearing either to occur in conjunction with a regular meeting, or specially set to determine whether the existence of those documents should require a finding of willful failure by the executive director to turn those over. in that way, I think if there is something to talk about in the file, we'll talk about it. If there's not, then it seems we've spent a lot of time and I think truly exhausted the issues, and our finding would then stand.
I would be fine with that approach. I think it is a good balance of what we've discussed tonight. But it seems like you have other thoughts.
I think it ultimately, it does what I would like us to do, which is relook at the documents, the Ethics Commission documents. I'm pausing at the process of saying there wasn't, of making a finding and then looking at the documents and then undoing that if we found that there were. I realize you want to, so I'm wondering if there's another way we could preserve where we got to tonight without a crisp finding or a final finding or a subject to kind of finding.
Yeah, well,
that would make it not, it's all over, take the heat that I would expect from people saying you did it before you were finished, not to script our friends, in case we do have to come back.
Yeah, no, I was not suggesting that we would find in advance that there wasn't a failure to disclose the documents. I was just saying that we should find what we can find today, and that if there are documents that need to be turned over, then we.
So could you say again what it is you think we could find today?
I think we can find that there is no willful violation of the Sunshine Ordinance with respect to the investigative file of the Ethics Commission or of the Controller's Office.
Okay.
Those documents are protected.
Okay. So you're basically saying
extent,
number 2 with regard to the Ethics Commission and the files of the...
With regard to the Ethics Commission, with regard to the Controller's Office,
okay,
all of it. Now, whether or not there's correspondence between the Ethics Commission and the Controller's Office that's non-privileged, that shouldn't be in the investigative file or isn't in the investigative file, perhaps there are such documents. And if there are such documents and they're turned and Ms. Herrick finds them, then I think we should have another hearing about it.
And that would be just reserved as a separate category of documents, if they exist.
Right. I mean, I think what we're all appreciating is that as a practical matter, it's very difficult to determine the confidentiality of documents that you cannot see.
Exactly. Right.
And unfortunately, that's where the law puts us in. It's odd and, frankly, I think unfair. But
she wouldn't let us do that.
That seems to be where we're left.
What it sounds like you're suggesting is that you make a finding as to part of the records that there was no willful violation of the Sunshine Ordinance or other public records laws, and then continuing the hearing for a determination on the remaining documents, the correspondence between the two departments. Is that right?
I guess that's right. Yeah. Sir, public comment is closed. Mr. Shaw, I'll give you a minute. I'm not sure what you have.
I just want to note, Mr. Gibney indicated Ms. Herrick was stepping into the shoes of the executive director, right?
Can you get to your point, please? Really, we don't have to give you this opportunity.
You're going to let the acting in the shoes executive director determine herself the contents of those files? Why can't you carve out the time and you examine them so that it's not a member of the staff filling in for something the Ethics Commission apparently doesn't want to do itself?
You'd rather have us review the documents? Is that your position?
Absolutely. You could use a hearing officer.
Sir, I'm not going to hear from you. I'm not going to hear from you. Please, sit down.
I want to object to one thing only.
Sir, I'm sorry, I cannot, look, if I let you speak, everyone's got to speak, and we're not going to go forward with this.
But on the part of the voters, we passed a law that says 6724 is a law of this county, and you cannot just throw it out, Ben.
Can I make myself clear?
No.
I want an ethics commissioner, not a deputy city attorney, to review those files. I want you to look at them.
Can we turn off that mic?
I would be prepared to make a motion along the lines of Mr. Givner's suggestion, if that reflects what you were suggesting.
Ms. Herrick, are you still there?
Yes, I am.
Would you be willing to review the file, the correspondence file, to determine whether there are any non-privileged documents therein?
Yes.
Thank you very much. I don't know what that says.
And make a report to you so that it's clear, or to the commission.
Yeah, right, and we would need a report to the commission explaining the results of your review, if that would be okay.
Certainly, yes.
To the extent that you find documents that, well, you know, let me also ask this question. Can we, the Ethics Commission, know the volume of the correspondence file with the Controller's Office? Is that something that's publicly disclosable?
Is that question to me?
I'm sorry, that's to Mr. Givner.
Sorry.
Oh, okay.
I think what you're asking is, when Ms. Herrick reviews the documents, whatever documents they are, can she then describe them to you in a way that is generic enough not to disclose whatever confidential information is in them, in order to allow you to make a determination as to whether they should be public documents? I think the answer to that is yes. That would allow you to make your deliberation.
Okay. Can I also, can we know in this public session the volume of correspondence between the Controller's Office and the Ethics Commission on this matter?
Are you asking? I don't think the answer is available from Ms. Herrick now.
No, not from Ms. Herrick, but from Ms. Ng or Mr. St. Croix. I mean, I'm trying to understand how much we're asking her to review. Mm-hmm. I just know that the size of the correspondence file.
Right. Again, I can't speak to the Controller's Office's file. I can speak to the Ethics Commission's file. I don't see a problem with the ethics, if the people here know, Ethics Commission saying we're talking, you know.
Yeah,
how much
just ballpark.
An inch, 10 boxes, that's the.
Right.
I'm sorry, I really have no idea, and neither does Ms. Argumedo. The person who handled
less than a banker's box?
I believe definitely, yeah.
Litigator's rule of measure.
Mm-hmm.
Okay. I think we should make a motion along the lines we've described. Is there a motion to find that Mr. St. Croix and Ms. Lediju have not committed a willful failure to comply with the Sunshine Ordinance Task Force with respect to the investigative files of the Ethics Commission and the Controller's Office? We are particularly carving out, however, correspondence that might be in the Ethics Commission's files relating to the complaint and are with the Controller's Office that are not privileged. And we are directing Ms. Herrick to review those files.
So moved.
Is there a second?
Second.
All in favor? Aye.
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 Opposed? Hearing none, the motion passes. Ms. Herrick, thank you for your time. Thank you for agreeing to look at the documents. We appreciate that. We direct the commission to turn over that correspondence to Ms. Herrick as soon as possible.
You're welcome.
Yeah, thank you, truly.
Yes,
very
thank
much.
you very much.
Certainly. Thank you. I'm going to sign out now then.
Thank you.
Cannot blame you. Thank you.
Good night.
Good time for a baseball break.
Haven't gotten my update here.
The next item on the agenda is discussion and possible action on draft amendments to CFRO. I understand that we cannot actually decide this without 4 members. My initial thought was, hey, let's discuss it anyway. But I think in light of the depth of the discussion on the previous matter, I would vote to defer it until we have a full commission, or at least 4 commissioners, to discuss it. Any objection from my fellow commissioners?
No objection.
If we are going to go on for an extended time, I would respectfully request a restroom break, but if you think that would prolong things unduly, I will.
I was thinking that we wouldn't need much additional time to get through the rest of this, but I'm happy to take a break.
No,
I don't want to
no,
make anybody uncomfortable.
No, that's okay.
The next item on the agenda is the annual report for fiscal year 2011 and 2012. Mr. St. Croix, would you like to introduce this matter?
In the interest of brevity, the report is self-introductory. Most of you are familiar with this process, so I present the draft for your consideration.
Public comment?
Says that there are over 400 Twitter users who get updates, over 250 Facebook users get updates, but it doesn't tell you how many whistleblower retaliation complaints were reviewed by the Ethics Committee in the whole year. Thank you.
Commissioners, Ray Hart, Inspector, San Francisco Open Government. Despite all the complaints in this report regarding the low staffing levels, it is hard to see what benefits the public gains for expenditures of millions of dollars each year. Even the budget figures listed in this report are impossible to understand. The latest 6 years of figures range from $3.6 million to $8.4 million. That's an average of $6 million a year. What do the citizens of San Francisco get for this $6 million amount? Honestly, reading the report, there would not be seen to be much bang for the buck. I've heard estimates anywhere from 1.2 to 1.8 million just for the recent investigation of the sheriff. The referrals from the Sunshine Ordinance Task Force are still, after 14 years, not being heard. The civil grand jury report is dismissed in this report with only a link to the report and a link to your response. So basically, you didn't even feel it was worthy of commenting on the civil grand jury report. What exactly do the citizens of this city get for this $6 million a year? If you kind of price it out, this commission, its operation costs us $500,000 a month. $500,000 a month for what we just saw, which to me was just a Rube Goldberg, throw it together, we have no idea what we're doing, so let's just put something together now and hope the hell it works. I think the Board of Supervisors saved your behinds, because if they had actually voted to remove Sheriff Marikarimi, it would have gone back to court, and the judge would have said, recall is the way you overturn a lawful election. Not this put together, jury-rigged mistake for a procedure which you had to then somehow try to publicly defend. And if you break it down another way, we spend, with your 17 employees in this report, $352,000 per employee per year. And I'll be honest with you, I come to these meetings and I can't see you doing a damn thing to make this city any more ethical or any more open. In fact, what you just did in the last case was say, well, We haven't seen the file. They won't tell us what's in the file. We don't know what's in the file. We don't know whether it's confidential or not, but we're going to find that the people that are being charged for withholding documents are not guilty, and then we'll go look to see whether there's anything in there that indicate they might be. Talk about back asswards. That is it.
You know, let me just, is there any other public comment on this? You know, let me just say, I didn't reiterate the analysis that was provided by Ms. Herrick in the memo and that she stated in response to the questions, but there is a important need to keep investigatory files confidential. And the bases, I think, are quite clear. Any individual who files a whistleblower complaint is going to be subject to pressure to make a disclosure if such disclosure is possible. And we need to protect not just Dr. Kerr, not just Ms. Rivera, not any specific individual whistleblower, but we need to protect future whistleblowers as well from a potential compulsion to disclose. And investigatory files, if any part of them, frankly, were disclosable, you run, I think, a very serious risk of not being able to conduct the investigation. Who is going to talk to an investigator if they think that any part of their interview, that the fact that they were interviewed, the time that they were interviewed, it could be disclosed? And I think there is an important public benefit to being able to protect them from such disclosure so that we can do the very work we're talking about. So, you know, the notion that we just, you know, we don't care about what's in the files and we just want to, you know, rubber stamp, you know, the analysis is totally unfounded. I think to the contrary, we have spent an inordinate amount of time trying to get this right. And frankly, I resent the idea that we haven't given it detailed thought. Additional public comment on
Mr. Herr, Paul Currier again. I wanted to respond thoughtfully to the statement that you just made, because I sat in this room all the way up to and including the time of the bomb threat, and when you left the room on June 29th, I stayed in the room, this exact room. So I wanted to mention this argument that you just made and apply it to Aliana Lopez, because you know what? Her attorney-client privileges were breached, and she claimed that Ivy Madison and her attorney husband presented themselves as lawyers and that all that was confidential. And then you know what? Then they disclosed everything against her will. And then you guys went ahead and took all of that and adjudicated based on it. So you know what? I see the hypocrisy. Thank you.
Okay.
Thank you, Chair Herr, for clarifying the record and the bases for our decisions tonight.
With respect to the annual report, thank you for putting it together, the staff. One thing that I thought could be done differently is the highlights don't appear to be in order of importance or chronological order. I think they should be in either chronological order or order of importance.
We can do that.
I like the notion that there was a section on future initiatives and the kinds of priorities and values that we're trying to address. I think that in addition to carrying out the very specific responsibilities allocated to the Commission, like campaign audit and distribution of campaign finance funding and so forth that we're obligated to do, we're also attempting to make these things clearer, make them understood, and carry out initiatives that we did not craft or ask for, but responsibilities that are put in our laps that we try to carry out as thoughtfully and responsibly as we can. At the moment, I'm simply saying I like that there was a discussion on 19. I think one thing that we might do is consider how to bring particular items on this list back to us in the course of the year so that we can, some of them already will be, the CFRO revisions, the Sunshine Task Force, collaborative project to develop regulations that govern the way we handle those proceedings. So I think what I'm simply suggesting is that we look at it and see which ones wouldn't naturally come to us as an agenda item and see if any of them deserve our thinking about the perception of fairness, the public understanding, or matters that that don't have a driver of a decisional action to be taken.
I think that's a good suggestion. I was particularly pleased with the Commission's somewhat thankless handling of the procedural mechanisms relating to our Mirkarimi hearings. The documents were very publicly available and were quickly available in a easy to use, as easy to use format as I think is reasonable under the circumstances. The way that the summaries were put together, I think, was efficient and allowed the public to understand, for the most part, what we had done and what we were planning to do. And it was a behind-the-scenes and thankless task, but it was an important task, and particularly for public access to those documents in a quick, efficient way was quite valuable, and appreciate that. Any other comments on the annual report?
No, thank you I was just going to say thank you for putting it together, and I do like the suggestion of bringing the future items back through the year as it makes sense, so that we can revisit and see where we are and if we're on track with the goals we set out.
Can we identify in here the number of whistleblower complaints we've handled?
Yeah, what I'll do is, there was actually a separate annual report on the whistleblower program. In fact, I received it last week. So what we'll do is, at the appropriate place in the report, mention that report and add a link to it so that people reading this know where they can get comprehensive information about that. And I'd just like to clarify that our operating budget in the last 6 years has averaged $2.3 million. That's all of the expenses of the commission. All of the other funds are dedicated solely to public financing. And all that money goes to candidates.
Could you, Jack, just take a look at the document and see if that seems crisp enough for readers to make that distinction?
Sure, yeah.
Even clearer?
Should we, is there any action that needs to be taken?
The report.
Is there a motion to adopt the report as amended by comments from the commissioners?
So moved.
Second?
Second.
All in favor?
Aye.
Aye. Opposed? There being none, the motion passes. The next item has to do with minutes.
I want to just bring something up regarding minute policy.
Okay.
In general. In the past, we have not published draft minutes on our website simply because when there are changes made, once you publish something on the website, it's kind of out there in the ether. And we didn't want people to confuse the draft ones with the permanent ones. That never has been a problem before. At the last meeting, the last two meetings, I guess, members of the public were concerned that they didn't have the ability to see the minutes in advance. Now, the minutes are available to the public at the office, but there's a simple answer to that concern. So in the future, we will actually post draft minutes on the website in advance. We're going to do it in a format that permanently reflects their draft status, and then when the permanent ones are posted, they'll be the final version. So we're going to change that policy to make it more user-friendly.
I think that's a good change. Any public comment on the minutes?
Minutes or report?
Paul Courier again, yeah.
We already did the report.
I was one of the citizens of the city that complained that all through the Mirakarimi hearings, I didn't see one meeting where proposed minutes were ever published as we went meeting to meeting to meeting. And the Sunshine Ordinance states that draft minutes must be made available within 10 days of the meeting. So the whole Ethics Commission was in violation of the governing law of this county, which is the Sunshine Ordinance. And I say that in the sense that in 6736, the Sunshine Ordinance reads that it supersedes all other law in the county. And so that's with regards to public access to information, and minutes of meetings definitely is not something that the Controller's Office can say is privileged and confidential and we can't share it with anybody. These are minutes of open meetings that belong to the public. So I complained about that. And when I filed my Sunshine complaint, because I was really upset about the bomb threat. Personally, I was upset about not being warned to leave City Hall. I mean, you guys thought it was, I listened to the sheriff, and the sheriff, Mirakarimi, before he left, and Sheriff Sane, who stayed here, he said, we never got any protocol to clear the building. And I was surprised that Vicki Hennessy, acting sheriff, had called John St. Croix and told him on his personal cell phone, according to his statement made to KCBS in this room on the 29th, that she called over because there was some threat on the mayor's life. Well, now turns out it's a bomb threat. And I would like to think that the mayor cares about the citizens of the city and county. I would like to think if there's a bomb threat in City Hall, the whole building's evacuated. I was upset that in the minutes, we can say easily that on the 29th, Mr. Herr, that you recessed the meeting and then adjourned it at the end, but I personally witnessed you adjourn the meeting. As soon as the bomb threat came in, this meeting was adjourned. I saw you do it with my own eyes, right there in that chair next to Mr. St. Croix, I believe is where you were sitting. And so to hear of a meeting's adjourned and then it reconvenes, this is unusual, and none of it's in the minutes. So the actual record of what really happened in this room is not accurate. And I object to that. And when I said that this was done in collusion with the mayor and Steve Cava and Mr. Schur, Captain Schur over at the SFPD, and I said that there was collusion going on between Dennis Herrera and all this was done to keep the mayor, who was perjuring himself right there in that chair, and to keep him from continuing perjuring himself and protecting himself, and this was done in collusion. This is organized crime, and I've been talking about this publicly in meeting after meeting because it's time to stop. And I've been asking for the feds to come in and start arresting people. I'd like to see supervisors arrested. I can't believe the organized crime that went on with Park Merced. All of you will go home to a bed tonight. There's 300 people at Park Merced that are Section 8 cases that should have been heard in federal court that have been evicted in Judge Kiddishay's County Superior Court right here. This is incredible. It's incredible. It's incredible. And for you to allow illegal minute processes.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I believe it is time for someone on this Ethics Commission to show some level of integrity by asking the Executive Director, John St. Croix, in public why he is so determined to keep the actual thoughts of the public out of the official record. I'm talking particularly in this case about the meeting minutes for July 23rd, where I brought up this same issue and was told by Commissioner Studley, we follow the law. I read you the law earlier. We are talking about constitutionally protected political free speech. Mr. St. Croix takes that free speech out of the official record, appends it somewhere else, and in the place where it lawfully should appear, substitute his approved, censored version of our comments. Anyone can read these minutes and see that what I said and what Mr. St. Croix says I said are not the same. I am censored, as are other members of the public. To continue this, the Ethics Commission must show a compelling state interest. If you try to take what a member of the public says, their free speech is protected in its writing and its publication in a government document. Mr. St. Croix does not like what members of the public have to say and wants to retain the ability to marginalize that free speech and substitute his own interpretation. That is viewpoint discrimination. It is what is specifically under the law not permitted. And Mr. Herr, you tonight made it very clear you don't like what I say. And I have been before bodies before because I was questioning what they were doing or how they were doing it. They come back and they make some sort of specious argument, which you did tonight, which didn't even address what I was talking about. You just explained away your own behavior, and you can sit there and smile all you want, but it's what you do. You don't like what members of the public have to say, and you want to make sure it doesn't actually make it into the record. And ask Mr. St. Croix. All he has ever said is the city attorney says we can. What's the purpose? If your free speech was misrepresented in the record, and you felt that the reason you had sat for 2 hours and made that statement so that your public comments would be accurately reflected, how would you feel if a functionary was allowed to simply put it somewhere else where people were less likely to see it and then put in what he says you said? And just look at those. Look at what I wrote in my summaries and look what he put in the record and tell me they're the same.
That's not an encouraging sound. Any comments on the minutes?
I have a very small correction. On September 24th, page 3, paragraphs 1 is quoted in, right? Third paragraph. The next to last sentence says that I suggested that the commission would be able to amend. I think it would be more accurate to say would be able to amend the regulations if the task force meets and has suggestions. What I was trying at the time was to suggest that we could go forward with the amendments, and that when the time comes that the Sunshine Task Force is able to comment, we could revisit and incorporate recommendations that they have, but not to hold up while they're not able to meet. It's a small point.
I think we should make that change. Any other changes to the minutes?
Oh, that's what you meant. Uh-oh.
Big storm.
Can you hear the rain?
Yeah.
That's what that.
Is there a motion to adopt the minutes of the
So moved.
July 23rd, September 24th, and September 11th? Is there a second?
Second.
All in favor?
Aye.
Aye. Opposed? Hearing none, the motion passes. Executive Director's report.
Okay. Two highlights. One is I expect that the November meeting will probably run kind of long. We're going to go back to Sunshine. We have the item we kicked over from tonight, which deals with the Run Ed Red issue.
Is it November 26th? Is that the, never mind. I can check.
I think it's, yes. And it is the first Monday after Thanksgiving. So if people are on travel and everything else, you might want to remember that too.
Meaning what?
Remember that you have a long meeting ahead of you.
Right.
So
read over.
what we are going to do our best to do, and I think what we'll be able to do, is have packets ready the week before Thanksgiving so that you'll have them during the rush of the holidays. You'll have extra time.
Like by Monday, the Monday before?
Hopefully the week before.
Oh, even the week before
Yeah.
that. I see what
Right.
you're saying. Got it.
Okay.
That would be great.
And I've been having trouble, I had trouble trying to schedule a December meeting because our normal meeting date would be the 24th, the night of the 24th. So I'm going to give that. I'm going to give that one more go around, but we may not be able to have a December meeting. The final thing is, one of the requests for future meetings at past meetings was that we do a discussion of the report that the budget analyst Harvey Rose did, comparing us to LA. We've decided that before we have that discussion here at the commission, that we should have interested persons meetings with the public and get some input from them. So we scheduled 2 of those for December, and then we plan to bring that report before you for the January meeting.
That's a good idea.
But can I ask a question going back to the scheduling?
Sure.
So for December, there's nothing on tentatively scheduled for the 14th, December 14th?
No.
Okay.
Not
Okay,
at the
thank you.
moment, yeah.
Okay. Anything, public comment? Public comment on the Executive Director's report.
Yes, thank you, Dr. Kerr again. This chart on the first page of the Director's report that has 6 categories of investigations and enforcements, Mr. St. Croix introduced that chart in early 2006. But in the first month that this chart was introduced, there was whistleblower/Sunshine Ordinance. Since then, in the last 6 years, the word whistleblower has not appeared. Now, whistleblower retaliation is arguably a more serious problem than any of these because it involves the destruction of someone's professional life and personal life too. And it's part of your responsibility to oversee whistleblower protection. So I would suggest and plead that whistleblower retaliation be one of the categories so that you know how many complaints come in and you can track whether any of them get substantiated. Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I do read these reports. I read every one of them front to back, and I go back and make notes on them and everything else because I really do want to come here and make meaningful comment. For example, category number 2, investigation and enforcement programs, number of complaints. What does that tell us? How long have those complaints been sitting? I know for a fact the 9 from the Sunshine Ordinance Task Force have been sitting there for God knows how long. So basically, I don't think it's unfair to assume that some of these other complaints may just be sitting in somebody's desk aging. And eventually someone will get around to it and someone will put it up. These really are meaningless statistics. 9 people filed a complaint. How many were referred from Sunshine? How many have you heard? Well, we know that. 1, Jewel Gomez. Where did that go? Nowhere. Because the mayor only wants to use you if it suits his political ends. I told you that before. He hung you out to dry. He wanted to get rid of the sheriff. I personally think he wanted to take control of the sheriff's office. Get rid of the sheriff, put his own person in, and say, oh, look how wonderful it runs under the mayor's office. Why have an elected sheriff? But the bottom line was, it didn't work. Now, these sunshine complaints, I voted in the very first election in San Francisco in 1999, and it happened to be the latest iteration of the Sunshine Ordinance. And I've gone back and done the research and seen that you have not taken a single complaint for a hearing except the Jewel Gomez. And I think the only reason you did that was because the civil grand jury pointed it out in their report. And you wanted to be able to say, no, that's not true. We heard one. You know, it's really awful. And you can be as dismissive as possible. It is really awful to sit in board and commission meetings and watch citizens denied their right to speak, being told they're not allowed to speak about certain things, and then they have to go to the Sunshine Ordinance Task Force and fight for those rights under the Sunshine Ordinance. And then to get enforcement, they have to have it referred to you, and you simply allow Mr. St. Croix to dismiss them all. And you wonder why I'm a little ticked. I have 4 things on the 150-word summaries I mentioned before that have all been approved by the Sunshine Ordinance Task Force, and Mr. St. Croix spent 134 pages dismissing the one against you so that you wouldn't have the guts to hear it.
Discussion on items for future meetings. On the executive director's report, the list of whistleblower complaints, is that something that is it true that we used to have that and we've taken it off?
We get those in a confidential report, don't we?
We do.
We get those in a confidential listing.
I'll see what we can add back on again.
Okay. Public comment on number 8.
Could I ask you to repeat what you said about the whistleblower complaints? Will they be in or not?
Mr. St. Croix said he's going to look into what additional information we can put on there relating to whistleblower complaints. Is there a motion to adjourn the meeting?
So moved.
I did want to make a comment on 8. You were talking to Mr. Kerr.
Oh, you did? Okay.
Yes. Again, Ray Hart's Director, San Francisco Open Government, and you can sit there and you can attribute every negative and malicious and whatever other motives you want to me. I don't care. Very frankly, I've told you and I've told every other body I've appeared before that my only 2 reasons for going to public meetings are to ensure that members of the public are allowed to speak and that they're allowed to gain access to public records, which they need in order to speak intelligently to certain issues. I went to an Arts Commission meeting where I watched a commissioner respond to a public comment, which was very, very polite, suggesting they needed to have some sunshine training, with comments like, Mr. Whoever you are, I don't appreciate it being lectured by someone like you. And I'm going to do everything in my power to make sure you're no longer part of this anymore. When it gets to the point where people who take a vow to support and defend the Constitution start to abuse members of the public, you know it's gone too far. And I know you don't like the comments. Basically, what I found in a lot of these city commissions, they want to take credit for everything that goes well and avoid responsibility for anything that isn't going well. They want credit for showing up, but they don't want to be bothered with a lot of the work. I had one member of a commission, when there was an argument going on, tell one of the witnesses, when they referred to one of the documents that had been submitted to them, they said, well, I don't need to read the documents. And it's time and time again, and the reason I do this is for one simple reason. There are a lot of people who, getting up in front of a public body, especially on public television, are afraid to do it. They're just afraid to come up to a body and say, you know, I don't like what you're doing. And that's another part of the First Amendment, to petition government for redress of grievances. And when I started coming here, I tried to be polite, but when you're polite with you folks, it gets you nowhere. You get someone who says, well, we follow the law if we have to. And you say, well, here's what the law says, and the person sits there and looks down. Read the 150-word summary thing in the minutes. It's pretty clear. And I'd like to ask you something. If we ended up in court and I subpoenaed all of you, and before a jury, a lawyer got up and said, well, what did that 150-word summary should be in the minutes mean to you? Did it make any sense that the city attorney says you could put it somewhere else? I think you'd have a hard time answering that question, wouldn't you?
Is there a motion to adjourn the meeting?
I'd like, he saved me from what I was going to say. So moved.
Second?
Second.
All in favor?
Aye.
Aye.
Opposed? Hearing none, the meeting is adjourned.